Good morning. Thank you for inviting me to this wonderful conference, Andy and Rod, and I couldn't agree more with Jeffrey. What a beautiful campus you have here and a beautiful backdrop. The mountains here, it's just spectacular. And Professor Amar this morning pointing out his passion for the Constitution. I share that passion. And I tell my students often that in many ways our Constitution is very current on structure of the structure of government, separation of powers, federalism. We're about to elect a president through an electoral college that was created in 1787. So it's still very much a current document. And the framers did compromise on human rights, and that is the imperfection that was ultimately changed. But it is a document that I take great pride in and feel equally passionate about. Well, my presentation today is on I wrote a book on Scalia and argued that he was a Hamiltonian justice, that a lot of his opinions were formed in some ways by a Hamiltonian orientation to the Constitution. And he actually came to my institution in 2008. The book came out in 2006, and he came to the University of Central Missouri, and he actually endorsed the thesis of the book, which actually really surprised me, and to this day still surprises me, that he actually admitted to that Hamiltonian influence on separation of powers and federalism in particular. So I'm going to update my book, so to speak, and point out how that Hamiltonian influence impacted Justice Scalia's decisions across many different areas. So, and this is somewhat counterintuitive in a sense, because Scalia said that he was not an intentionalist, right? He believed in the original meaning. And so this is a little bit counterintuitive, and that's I was equally surprised at his admission that Hamilton did have an influence on him. So what is a Hamiltonian conservative? That would be the first thing we can examine. Hamilton, of course, was a complex thinker, as was Scalia. But I think the two main pillars of sort of, in a large sense, of Hamilton's political philosophy is a certain anti-democratic disposition. You might say a distrust of popular democracy. This comes across in many different areas. He thought people were passionate and self-interested, and he thought that the people were at their worst in assemblies where you could have mob rule. And so he took issue with Jefferson. Jefferson said that the voice of the people is the voice of God, and Hamilton disagreed with that. The people are turbulent and seldom make decisions that are just. The second major pillar of Hamilton's political philosophy, I would say, is that he made some exceptions. He believed that a few choice spirits could overcome self-interest and act in the interest of the public good. And so Hamilton's going to be our founder who made the case for a natural aristocracy of talent. So he talked about incentives in the Constitution to attract people to their offices, lengthy and permanent tenures for the executive, judiciary, and the Senate. He would say that we need to go as far as we can in the area of security that Republican principles would admit. And an important buttress of this was his favorable view of political power. If you're going to have people that are going to serve as elites in your system of government, then you have to give them power. Once you have a system of separation of powers and federalism, then you have to trust your elected officials to exercise that power. And I'm assuming that you're seeing the slides fairly well. All right, so I have come up with 5 different constitutional principles that I think Hamilton championed. There perhaps are more than these, but I think these are central. Separation of powers. I actually think Hamilton, at the time of the founding, was our first formalist. He believed that Congress was the institution that was the most dominant institution and would try to encroach upon the presidency and the judiciary. In a number of different documents, he would argue for a strict, formalistic interpretation of separation of powers, which Scalia would, of course. He supported and championed an energetic executive, both in Federalist 70 and the Pacificus Essays. John Marshall is often credited with the sole organ theory, but in the Pacificus Essays, of course, Hamilton makes the case for the president being the sole organ in foreign affairs. He also would make the case for broad discretionary powers to the executive under the vesting clause of Article 2 of the Constitution. And I'm just going to work through these rather quickly because I know we are a little bit short on time. An elite judiciary that would have, judges would have the standard of good behavior that Hamilton was very, very supportive of, because that institution would serve as a check on the popular branches of government and the state legislatures. Federalism, Hamilton was not a big supporter of states' rights, as you know. Did not believe strongly in the 10th Amendment, and at the New York Ratification Convention argued that the word clearly ultimately get the deletion, or some recommendations were expressly that the powers of the government should not be limited to clearly or express powers. That his basic view on federalism was a structural argument. Some people call it a political process argument, that the states would be best protected by the political process, not through the judiciary, but the process itself. View of the Bill of Rights, Federalist 84, where Hamilton audaciously argues against a Bill of Rights, that it's both dangerous and unnecessary. And these 5 constitutional principles, I believe Scalia championed during the time that he was on the court. Also, very interestingly, he would, in speeches fairly early on, align himself with Hamilton. So 1982, he gives a talk with the First Federalist Society convention at Yale University, and Scalia at a conference on federalism. He listens to some of the papers presented there, and he talks about if a resurrected and updated Hamilton was here, he would not approve of the substance or the tenor of the papers that were presented. Of course, in the early 1980s, the Republicans were talking about states' rights. Remember Ronald Reagan talking about the government is not the solution to our problems, it is the problem. And Scalia, always the contrarian, takes issue with that quite clearly here, saying that the national government has a role and can be used for certain purposes. He never lost that viewpoint of national power. 1986, very interestingly, he gives, this is the address at which many people credit him for original meaning, that he's the patron saint of original meaning. And he actually challenges the first iteration of originalism, original intent. And he said that we shouldn't be looking at intentions, we should look at original meaning, the text, and what it actually means, the popular understanding at the time of the founding. And toward the end, he gives what I call a Freudian slip. Most people say that James Madison is the father of the Constitution. And so this is Scalia. It's not that the Constitution must mean this because Alexander Hamilton thought it meant this and he wrote it, but rather that the Constitution must mean this because Alexander Hamilton, who for Pete's sakes must have understood the thing, thought it meant this. Very, very interesting. And I have to admit, when I was in graduate school and everybody was saying Scalia is a conservative, O'Connor's a conservative, Thomas is a conservative, Rehnquist is a conservative, these speeches were very illuminating to me that he was a very unique conservative, very supportive of national power early on and a strong executive, in many ways foreshadowing the Bush II administration. So what about Scalia and the pillars of Hamiltonianism? Anti-democratic views. An opinion he wrote for the court, separation of powers decision, where Congress tried to overturn a prior Supreme Court decision. Scalia writes it, and he talks about the populist state legislatures and how the Constitution itself was a constitutional reaction to that radical populism of the states at that time. Not very complimentary view of states and popular democracy. Then he loved to give this speech. I heard him say it so many times, where he would say, my most important role is to say no to the people. And he would expand on that. People be damned. I stand between you and the Constitution. If the Constitution says something that is in conflict with a particular law that was passed, then I have to say no to that particular idea. Another anti-democratic proposition. And a number of his opinions that we can talk about actually supported what he viewed as the core powers of the courts. Favorable view of political power. Here, Scalia in speeches would talk about that government had to have power. In the absence of power is anarchy. So you must give that power. He would quote Hamilton and Marshall on that particular proposition. He rejected strict constructionism, as Jeffrey pointed out, a fair reading. He was not a strict constructionist of the Constitution. He called that a degraded form of textualism. At our university, he talked about, he was asked, do you believe in a general right of privacy? He rejected it. He said, good God, that would be anarchy. So this is not a libertarian conservative, is my ultimate point here. There were some opinions that might be the exception to the rule, like his opinion in Heller involving gun rights. But by and large, when he defended rights, it was a have-to proposition. The text required it, or the tradition required it. It wasn't that he gave a ringing endorsement of liberty in these opinions. In one case, he talked about, he ridiculed the idea of a Thoreauian, you may do what you like as long as it does not injure someone else, beau ideal, a Millian or Thoreauian idea of liberty. His nickname on the Court of Appeals, which I find so fascinating, was New Monarchist. I mean, how do you get that label? Abner Mikva, who was one of his liberal colleagues, I think got it right when he said that Scalia was a conservative, but he wasn't anti-democratic. So Scalia certainly supported political power. He sometimes said that he should be the poster child of the criminal defense bar. But this next slide shows that statistically that can't be borne out. He sided with the government, not necessarily the federal government, but the government in 68.7% of civil rights cases, 71.6% of First Amendment cases, 72.7% of criminal cases. He was the third most conservative justice on the court since the 1930s, only behind Rehnquist and Thomas in terms of voting behavior. Constitutional principles, separation of powers. I've already mentioned it, and time might not permit us to go into all these details. We could during the Q&A session, but one of the court's strong defenders of a formalistic interpretation of separation of powers, which of course inures to the benefit of the judiciary and the executive branch, because the Congress is supposed to be the dominant institution. Sinar versus United States, Morrison versus Olson, Mistretta versus United States are very important opinions in that area. Interesting exceptions to the rule. Scalia long argued against the legislative veto when he was in the executive branch, and then he signs a dissent in the line item veto case that where Congress gave power to the president, he was not so formalistic. Very, very interesting. So formalistic, except with some exceptions where the executive is given power rather than it's taken away. Non-delegation doctrine, I've been talking to Ralph Rossum. Justice Thomas, of course, has rekindled the idea that there should be some substance to the non-delegation doctrine, that we should go back to sort of looking at the court's test in that particular area, the intelligibility principle. And Scalia had never had gone in that direction, that the executive branch should be given powers, or he certainly wasn't going to enforce a very strict interpretation of the non-delegation doctrine. Pro-executive, closest connection with Hamilton, I think. The biography, I think, is very, very important here. Worked in the executive branch in various capacities. He was an administrative law professor. And I think in many ways his jurisprudence in this area was an attempt to restore lost powers to the executive branch during the 1970s, where he talked about that being a very difficult time for him and at that time in his life. Hamiltonian interpretation of Article 2, and judicial opinions that supported a strong executive, from the sole Oregon theory, war on terrorism, executive privilege, immunity from civil lawsuits. Zavotsky versus Kerry might be an outlier that we could talk about, but generally a very strong defender of the executive branch. Elite judiciary, how are we doing in terms of time? Okay, very good. So the elite judiciary idea, even though Scalia would call the Supreme Court an imperial judiciary and accuse his colleagues of creating rights that did not exist in the Constitution, he supported a elite judiciary. As late as 2010, so I'm going to skip a few things here, he was asked whether there should be term limits on federal judges. You know, very popular idea. And Scalia says that's a solution in search of a problem. We shouldn't have term limits on federal judges. Very interesting. Federalism, I will just state, I apologize about that he did defend a structural approach. Ralph Rossum has written on this particular subject, the 17th Amendment, that Scalia has criticized for eroding state powers, and he called it a burst of progressivism at the start of the 20th century. A structural view, also a very elitist view of our system of government. But he never lost some of that Hamiltonianism, and I think Gonzalez versus Raich is a good example of that, his concurring opinion in that case, in which he supported federal power on the issue of the medicinal use of marijuana. Bill of Rights, Scalia would give speeches in which he would kind of downplay the Bill of Rights. And he believed that the 14th Amendment, Akhil Amar just spoke to it, whether Scalia kept in tune with the 14th Amendment. He did not believe as original matter that the 14th Amendment incorporated the Bill of Rights. But he did make some exceptions in that particular area. So I know I'm running short on time. So I would say that, just to conclude, that there is some very interesting areas of common ground between Hamilton and Scalia, even in terms of personalities. Hamilton was not a compromiser, nor was Scalia. I find that very, very interesting. There are some outlier cases, but even in 2010, Scalia was asked, would you support the Federalists or the Anti-Federalists? And of course, most people would think he would support the Federalists, but then he expanded on that. Of course, he said the Federalists. He said, I always told people in the Federalist Society that the word Federalist included the word federal. Never lost his appreciation, I believe, of federal power versus state power. Well, I apologize if I've gone a little bit long, and you've been very patient, so thank you very much.